All right, so this stream we're going to be talking about the appointment and the removal of trustees. Today, this will be about an hour long. So today we've split the two things up into two. We'll start doing duties. Duties is going to take multiple sessions. But the idea of getting trustees in, and again, largely here we're thinking about the deliberately created trust, express trusts created through the will of the settlor. Not really thinking so much about trust created through operation of law, although most of the rules operate the same. We think about it, you've got willing trustees and unwilling trustees, and a lot of the rules operate the same, but what we find is that when you're analysing it, and certainly when you're going and doing reading on this, in most situations we're really thinking about the operation of express trusts. There is a distinction between inter vivos and testamentary in some situations, but largely these are express trusts that are set up. I'm not really concerned about the distinction between fixed and discretionary, but express trusts in the general sense. Okay, so we're going to kick off with just by talking about how and where these things sit. One of the key things to note, the most important thing that a trustee must be able to do in order to be a trustee, and it seems really obvious when I say it, but it's the ability to actually have legal title. You need to be able to deal with property. And so if we think about that, natural persons in most situations are going to have the ability to be trustees because they can deal with property. And in other situations, such as incorporated societies and corporations, they will have the same ability to hold property. And you may be aware that it's actually quite common in business and in the operation of family trust and similar sort of arrangements to have a corporate trustee. The Corporations Act allows you to create corporate trustees, and they actually charge a differential fee as well. I think you can, don't have to pay as much money for going and setting those things up. Now, you will find in some of the case examples where a company is set up to be a trustee, but it also does other things. Companies are vessels of investment for the carrying on of normal business practice. All right, and if you think about it, that's a little bit different to how trustees are supposed to operate. And so when we're trying to think about these, essentially these requirements of a trustee, yes, they are, they can hold legal title to property, therefore they can be trustees. The idea of appropriateness is something for you guys to think about in terms of the strategy that you'll have in setting these things up, because a non-zero fraction of this room is going to be setting these things up, either for yourself, for family, for friends, or in professional practice. And so it's quite common to have corporate trustees that are set up expressly for the purpose of being a trustee for one trust. You just pay the $500 registration, pay the $150 per annum fee, and it has one job. And there's the advantages, of course, of doing that. What is one massive advantage that companies have over natural people? Companies can't die. And so while you can go about replacing directors, and you can go about going and sometimes making changes to your constitution within limits, companies have this idea of continuity that natural people don't. Okay, and note that you can have incorporated societies under the various state incorporated corporation statutes. So their sections 21, 25 just say an incorporated society has legal personality. So does section 124 of the Corporations Act. And that's essentially what it is. Are you sui juris? Can you hold property? Yes. That's really the starting point with what you need to do in order to be a trustee. All right, and quite helpfully, they've defined that as well in the Trust Act itself. There you go. And so the idea is that, yes, you can have a trustee corporation, so something's set up specifically for that, or you can just have any old company that holds the property. Strategically, if you've got the choice, don't mix and match the two, because the duties of trustees are different from the duties of directors to go and make ordinary business decisions and make ordinary business risks. Trustees are to maintain low risk investments for the benefit of the beneficiaries, for their betterment, maintain the property. So the fact that those duties don't align means that you can run into difficulty when you've got one company trying to essentially wear multiple hats. And that happens with us as natural people. I mean, I'm a trustee and my family trust at the moment, because me as an individual has a business and I will make ordinary business decisions, and some of those things might go badly. And so there's a non-zero chance that I might end up being bankrupt. Now, oddly, maybe not oddly, bankruptcy actually doesn't stop a person from being a trustee. You can be bankrupt and still be a trustee. And that's because there is a specific section in the Bankruptcy Act that says when you go bankrupt, we kind of ignore things that you're holding in trusts. But as you could imagine, being a bankrupt is a pretty clear demonstration that you're not very good with money. And so the Trust Act itself gives the right, again, for a collection of the other trustees or a named person under the instrument to remove you without needing to go to court. So it's one of those automatic reasons that you can be removed as a trustee. But the starting point is, yes, you can carry on. If you are a trustee and you become bankrupt, nothing's going to carry on other than the ability for you to be removed without going to court. But note, the same is not true for companies in liquidation. Once a company goes into liquidation, they cannot be a trustee. The property vests in the Commonwealth at that point. And if you have a company and somebody has applied or petitioned to the court to liquidate that company, you'd be wise, again, if the situation comes up for you guys, you'd be wise to go have a meeting and actually move or assign that trustee. The beneficiaries can do that, or if they can't, then they'll have to go through court. And look, one of the themes you'll get from this lecture today is that going to court is awful. It's expensive, it's time consuming, it's got to be done in the Supreme Court. It's not what you want to be doing. If you can sort your own things out, sort your own things out. And the analogy I draw is the self-help remedies in contract law. In contract law, for example, if the doctrine of substantial performance, somebody performs a contract but needs a small amount of money spent to remedy the defect, you just pay them the full amount less the cost of remedy. It's a self-help remedy so people don't go to court. In trust law, the Act, and particularly Section 12 of the Act, just maps out ways for the settlor ahead of time to put in the instrument mechanisms to stop people from needing to go to court and stop that unnecessary expense as a result. Okay, infancy. So being a minor, being under the age of majority, which is 18 in Queensland. In fact, it's 18 in all jurisdictions in Australia these days. Infancy does not preclude you from being a trustee. But as with bankruptcy, they can always be removed. It's one of those defined categories that allows them to be substituted for another trustee. So infants can be trustees. Again, there's a bit of common sense aspect to this. Would you want a 10-year-old to be a trustee on your family trust? Probably not, because the whole point of having trusts is to separate the benefits and burdens of owning property. One of the glaringly obvious ones is that people, young people, very young people, don't have the capacity to make sensible decisions in regards to property, particularly real property. My 9-year-old doesn't know how to pay bills. There's no mechanism for doing that or learning that. Very, very, very hard. So while they can do it, they can also be removed by right, and it's usually not a good idea. Okay, so this appointment process is stuff that we've already learned about, and that it's that idea of having an instrument for an express trust, usually through a deed. Again, we know that strictly speaking, that's not a requirement. You can create a trust orally. There's some evidential problems, and we also know that we can't transfer title to the trustee, which is fundamental in the constitution of a trust. We can't do that for future property, choses in action, real property, a whole variety of other property that requires registration. So as a result, we know that in almost all situations we would do this in an instrument, a deed. But that idea of this appointment process, that happens when title has passed. We talked about trust of a promise, that idea of the various legal mechanics that happen if title hasn't passed. So trust that has been made, that hasn't passed, strictly speaking, there is no trust at that point. It's not until things have been transferred that something is constituted. And again, as a practical, mechanical series of steps, $10. I got my friend Rebecca to come to uni about 6 months ago and said, "Wait, I need you to be the settler on my trust." And she rocks up, barefoot, povo, as she described it. I bought her coffee, and then I said to her, "Right, now you need to give me $10. And she's like, "What? $10? $10? You're the settler on my trust. You were going to give me $10. And I'm going to take that $10 and put it in the bank." She was very angry with me about that, but that is essentially what happens. It seems silly. It seems like an arbitrary mechanical amount, but if you guys are a settler on the trust and somebody asks you to do this, bring a $10 note and an envelope to put it in. That's all you got to do. Take that and give it. Now, because you guys are aware that being a settlor, you don't need, when you are a settlor, to transfer all of the property. To create a trust, you just need to transfer a small amount. Again, $10 has been the classic amount for like 40 years. Once the trust is created, then property can be moved into it. Truesdale's case, for those that study tax law, will next year, is an anti-avoidance mechanism for whatever reason in the 1960s in Australia to try and stop people from using family trusts. They made a rule that the settlor couldn't be, if the settlor was also going to be a beneficiary or the trustee on the trust, then a punitive tax rate would apply. And the Barber Court very narrowly construed that and said that they used the word settlor. So if you've got someone else to be the settlor, then that's fine. And so that's what happens. So often accountants pay the $10, create and so that you literally, if you've gone to pay a solicitor to set up a trust, they will draft the thing for you, put all your names in it. And in fact, you guys would have had it in a first shoot where I gave you an instrument, an actual trustee to go through and look. They'll have a little search and replace document substitution thing, put all your details in it, get the $10 note, and you rock up to the bank and deposit it in a new bank account. That is the classic way that you go about setting up an express trust. Okay, but make note that the duties of these trustees at this point, again, for express trust, usually you want to get somebody willing to do it. In the trust through operation of law, though, they're not willing. Last thing they want to do is be a trustee for things for your benefit. And so you need to make note, though, they have the same duties. In particular, they have the same fiduciary duties to look after the property for the benefit of the beneficiaries. This slide shouldn't be new knowledge for any of you. It's just the maximum number of trustees. I've talked about this like 7 times. This is just defined in the Act itself. There's no common law rule. that says that you have to have 4, but the common law does say decisions of trustees must be unanimous. All right, and the statute says that charitable trusts are by majority. Again, this shouldn't be news to you guys. You may also recall when we talked about Oppenheim's case and this need to try and determine what is administratively workable in terms of number of people, but for private trusts, this maximum cap on trustees means that the courts have sort of had natural limits on how wide trusts can be as a result. And that's often used as the example. Tom certainly does it, to say, look, maximum 4 trustees. If 4 people working full-time couldn't manage this trust, it's administratively unworkable. Also note that in situations where you've got a corporate trustee, corporations can have stack tons of directors. They can have a lot of people going through and controlling them. They count as one trustee because it's only one entity, but that can offset the difficulties with workability in regards to this particular area. Also note that the Trust Act itself is old, in relative sense. It's older than I am, and so that some aspects of technology have rendered some parts of this act kind of redundant, particularly to do with things like minutes and communications, and things that we can do simply in terms of electronic transactions. But a lot of the stuff wasn't really available back in the day. All right, so none of this stuff should be news. Hopefully this stuff, maybe, is a little bit new. Now, and this is to do with removing of trustees, because there's a distinction in the Act between substituting trustees and actually removing them. The idea is, look, the courts, and again, Parliament trying to back up the courts in a lot of ways here, don't want to be the destroyer of trusts. They want these things to just carry on, and they want them to carry on in a very practical, no nonsense, no fuss way. And so that Section 12 of the Trusts Act maps out some rules, and you may recall from that first tube, in the instrument, it referred to the principal beneficiary. I don't know if you recall that. Principal beneficiary is not defined in the Act. All right, but what is described in the Act is the person nominated to remove or replace trustees. That is what was meant by the principal beneficiary in that instrument, and that's a common modification to the default statutory rule that says you can have a person who has the power to substitute trustees. And Section 12 lists essentially the reasons that you can do that. And in the instrument, you can add to that list. So the example is you could add physical infirmity, for example. You can add to this list a variety of other situations where you want to give that nominated person the power to substitute trustees. And so that again, stops people going to court. We don't want to go to court. It's expensive, it's time-consuming and wasteful. So that's a practical, mechanical thing you can do ahead of time. So just make note that to do that, yes, they can go through and remove these things, but it's straightforward if trustees are being replaced. It's difficult if they're being removed, particularly if they're being removed below a certain point. So they say that, look, if you're removing them below, I think it's 2. So if you're reducing, if they're 2 and it's removed down to 1 and that person's not the public trustee, then you aren't able to do that under the statute. But you can always replace them. Get a person willing to do it and swap the 2 over. No, in fact, that's actually the next slide. And so that's this idea that if a trustee doesn't want to do it anymore, there's a mechanical step for them to do that, provided there are another two remaining. Just another thing to note is that when trustees, joint trustees, so when you've got more than one, are holding title to property, it has to be as joint tenants. It has to be, by definition. If we stop and think about it, if you're trustees, if you had it as tenants in common, for example, you have one trustee holding this fraction, another trustee holding that fraction, that doesn't make any sense. That's essentially two trusts. And so that when title is held for property, I'm thinking real property, but it actually applies to personality as well. It's where there are multiple trustees, it's always held jointly. And a key thing to note that in Australia, all of your states are broke. They want to try and get money from everywhere. One of the ways they do that is through stamp duty. And stamp duty arises when things are conveyed from one person to another. And so that in situations like this involving trusts, you have to be careful, because generally there are exemptions for moving things to and from trustees. The Office of State Revenue accepts that that's not really a transfer. It's not really a conveyance worthy of being dutiable. But doing things like switching from tenants in common to joint tenancy will be. So just be a little bit mindful of doing that. Moving it from a natural person, me for example, to me as trustee for my family trust, that is going to be a conveyance, even though it's the same natural person. You need to really just be note of these things here, because in situations where you think this might come up, go off and do some reading. Tax. In legal practice, solicitors will often put their hands up like this and say, you need to seek your own tax advice. Right? This is not going to stop you being held negligent if you give advice, and they're going to end up being caught out by the Commissioner, the Federal Commissioner of Taxation, or by the Office of State Revenue. You do need to have a sufficient amount of knowledge about how tax works in our system, which is why I wholeheartedly recommend for those that have an elective slot to study taxation law. Unfortunately, we don't do the state revenue stuff, so you have to pick up bits of that as you go. Just be mindful. State revenue, what we call stamp duty, is the conveyance of property between entities. Okay. Some case law. I think a few weeks ago we talked about Gina Rinehart. This is another Gina Rinehart case, one a little bit closer in time to where we are now. So Hancock and Rinehart it's actually a tricky judgment to read. So I'm just going to talk about the facts. If you guys do want to go off and have a read, I said there are some parts, particularly where they talk about appointment of new trustees, that could be relevant and quite pertinent to go through and have a read, because Gina Rinehart is she's a difficult soul. Gina had you guys know who Gina Rinehart is. She's Australia's richest person, okay? And she was the wife of the late, is it Lang Hancock, I think his name was? And she inherited, she was the daughter of his? I can't remember. Either way, very wealthy person who owns a company called Hancock Prospecting and a variety of other entities that hold large mining interests in Western Australia. And she had 4 children, John, Hope, Bianca, and Jania, something similar to her own name, but it's spelled slightly different, Genia or something. And she set up a family trust and put in that trust the vast bulk of her wealth. So we're talking basically the shares, the beneficial interest of shares in Hancock Prospecting and other companies. Very, very valuable things. So she's got 4 children and a family trust The family trust was not to vest, so the instrument said this trust is not to vest until the youngest reaches the age of 26, which I believe was in 2011. Now, what do we know about the rule of Saunders and Vautier? You guys remember that rule? We talked about this in Pakistani paper mills and a few other cases. Turns out, if you are sui juris and you're not prejudicing the other beneficiaries, and you can just come and demand your share. You're the beneficial owner, you can ask for it, regardless of what's in the instrument, provided you're 18. That is a really important thing to note because it is not intuitive, and often, in situations like Gina had, not spoken about. I've known a lot of friends of mine over the years that have been beneficiaries in trusts that are under the impression that they had to be 25 or 30 or 35 or 40 in order to actually obtain the benefits under that. You guys need to leave Rule and Saunders and Vautier in the back of your minds, because if you can get unanimous assent from the beneficiaries, you can get your share, because you're the owner. You are the beneficial interest holder. If you're sui juris and not under a legal disability, you can ask for your stuff and end the trust. Okay, now, again, Gina Rinehart, she had her 4 children, and when times are good, when you set these things up because you love your kids, that's all well and great. I'm not sure if anybody here I'm not sure, the room's probably a little bit too young. I certainly have a trust for my little guy, and I hope we remain on good terms. But Gina, being a difficult soul, had falling outs with her kids. In particular, she had falling out with her son, John Hancock. Now, Hancock wasn't his name was Rinehart. He changed it by deed poll because he didn't like his mother. So you can sort of see where this is going. So you've now got the trustee, who's Gina, falling out with the beneficiaries, who are the kids. And this ended up being very public. They ended up with some very large legal bills in regards to this. Because the way that the thing was structured, you had the 4 beneficiaries, a very, very large amount of capital, only a relatively small amount of income was paid. The reason for that is that the beneficial interests were Hancock companies, which Gina controlled anyway. So she would make a decision as the primary director in all these companies to either pay distributions or not. And so they had a relatively large amount of capital, a very small amount of income. When I say small, like $4 million a year or something along those lines. But $250 million worth of assets. No, it might be more, maybe it's each. A lot, either way, a large amount. So they've had a falling out, and the way the instrument was structured, it was said that the youngest child, which I believe was Bianca, when she turned 26, they could ask for the capital. But they learned what the rule in Saunders and Vautier was and tried at an earlier stage to go through and do that. And so the children were sort of split in terms of how they were going to bring this this particular action. So I said, so John is the was the plaintiff here. Gina is the respondent. She is the trustee, and they were going to argue a variety of things. One of them is that she was being unclear to the various beneficiaries about how things were going to sit. And in particular, what she had said to them, she wrote a letter to them not long before this trust was about to, so the youngest child was about to reach the age of 26 in 2011. She wrote a letter to them saying, if I give you guys the capital, you're going to have massive CGT consequences, and it's going to send you bankrupt. Not only did she give them that, she actually somehow managed to convince PricewaterhouseCoopers, big, maybe it was Allison, no, I think it was PwC, to actually put that on their letterhead. So she essentially managed to convince them to write a letter, which, and the judge in this case looked at it and said, this is just patently, completely incorrect. But she wrote this letter saying, if we don't do something here, you're going to go bankrupt. Okay, that was the first thing. Second thing she did was to give them this letter very, very late in the piece. So she did it for Bianca just as she was about to jump on a plane, go overseas, so she couldn't seek independent legal advice about it, saying, look, we need you to urgently do this, to amend the deed, to push this date of vesting back to 2068, the year 2068. Otherwise, you're going to suffer terrible CGT consequences. And the kids, as I said, Bianca and John in particular, were very angry about this and actively sought to have her removed as a trustee. Okay. The other kids, Shania, I don't think cared either way, and Gina went again as trustee, offered Hope, one of the kids, a $45 million interest-free loan with very, very loose terms on repayment. So here you go, here's $45 million. If you sign a document saying you won't sue me for breach of fiduciary duty. All right, which she did. So Hope took no part in this. I don't think Janai did either, but certainly it was down to Bianca and particularly John, intensely disliked his mother. So this thing was set down for trial, and 3 days beforehand, 3 days before the trial date was about to come up, Gina resigned. Okay, she resigned. Why? Because she knew she was going to be absolutely nailed to the wall for a variety of breaches of fiduciary duty. And so the difficulty that the judge had here was trying to appoint a new trustee. And so they had to go through these rules. It comes from Tempest. I've got one a bit further down there. It's an old case. When the court is going to appoint a new trustee, which they have an inherent power to do under their inherent jurisdiction, and this is also mapped out and enshrined in the Act as well. Was it Section 80? The courts need to pick the best trustee to put in the place. And so here, the courts were stuck with something of a problem, because not only was Gina arguing with the kids are now arguing with each other. And so you've got this real problem. Who are we going to appoint? So Gina tried to argue, we should make a corporate trustee for one of her other companies the appropriate trustee. And the court said, no, that's not going to work because you control that entity. And therefore, there's no real change here. It's not going to change anything in regards to how this structure functionally operates. And so they went through the rules in Tempest. It's to do with really the welfare of the beneficiaries. When courts are appointing a new trustee, they have to look at the welfare of the beneficiaries themselves. But that's a tricky question when you've got different classes of beneficiaries, particularly life tenants and remainder men. You guys know what I mean by life tenant, where somebody, an estate, again, this is a land law concept, you can be appointed to have or hold something, usually real property, for life of a person, often the person you're giving the thing to, but doesn't strictly speaking have to be. Then when that person dies, it goes to the residual beneficiaries at some stage later. That's a real problem if you think about it in trust law, because if you've got different types of investment, high risk, high return investments are good for the life tenant because they don't care about the capital. If it's a high return or high potential rate of return, sure, it might be risky, sure, there might be a chance you lose the whole thing, but it's got a high rate of return. Whereas for the remainder men, they want low risk investments and low risk distributions to the life tenant because they want the capital at some stage in the future. So these classes of beneficiaries have to both be taken into account. That is a difficult thing for the courts to do, to take those two interests into account. And so while they start with this dominant consideration, they do appreciate that the welfare of the beneficiaries are not one homogeneous group. They're different and they have different and often competing interests. Certainly in the Rinehart litigation, the beneficiaries did have competing interests. Hope had already taken the money and made that contractual arrangement that she wouldn't go and do certain things. Whereas John at the other end of the scale, he wanted to get his share and walk away. So the next thing that the courts take into account, so they've got to take into account the beneficiary. That's the broad principle, the overarching principle. The next thing to look at is the settler's actual intent. What's their objective intent? Burns and Kendall these days would have been subjective back in the days of Reed Tempest. These days it's the objective intent, settlers, Burns and Kendall, where they take things into account as to what the settlor intended. Did the settlor intend to essentially allow the life tenant to make risky investments, or were they very, very clear about not wanting the life tenant to have much in terms of that distribution, to have very, very, very low risk things in order to benefit substantially the remainder men? Okay, that's the next thing I take into account. And the third one here is the impartiality. And again, this kind of flows from this not wanting to prejudice one category of beneficiary over the other. Impartiality of the trustee needs to be taken into account because we need the person who's the trustee to do this. They need to be able to stand back and act reasonably in weighing up the relative importance of each of those classes of beneficiaries. And that's hard to do. And certainly in a Rinehart case, the judge did struggle with that. And he said that, look, really we're picking the best of the worst. There aren't any good options. We're just taking the least bad option in choosing Bianca to be the trustee. It wasn't going to be John. Couldn't be Hope. And it couldn't be one of Gina's puppet corporations. So they made Bianca the trustee there. And this last one here is to do with impeding the trust itself. Again, this kind of goes back to the intention of the settlor. Whether a particular trustee is that we're potentially going and giving to do is actually going to subvert the underlying intention of the trust in the first place. Not just in prejudicing the various classes of beneficiary, but in making other decisions, particularly things like classes of investments and other factors. Is this going to somehow subvert the overall intention of the trust itself? Okay, those that have done company law will be aware there are things like replaceable rules, and you have companies that have rules in their own constitution. And so you have to make note that this power of the court to go through and vest title in a particular corporate trustee will actually trump rules that say you can't be a corporate trustee, or there is some defect in us holding. We will not hold this category of object. The power of the court to do that in the Act will trump or override the various rules in the particular trustee corporation's constitution. Okay. ANCO nominees, and I'll come back to that later. All right, I've used this phrase in this bottom one here. We'll do a little bit later, I think in a couple of weeks' time. This idea of a trustee sans detort. Trustee sans detort is a person who's acting or purporting to act as a trustee, but actually hasn't been validly appointed. Turns out if you do that, you can still be held liable as a trustee. If it looks like and it smells like you're acting as a trustee, but you haven't actually been validly appointed, either there's a defect either under the Act, under the instrument, or in the transfer of legal title, but you carry on acting as though you were a trustee, you can be held liable just as an ordinary trustee will. So that's Trustees de son tort. Okay, and I'm starting to sort of blur the boundary here between the appointment and removal information that you guys are going to need to know from a practical sense. I mean, you will be assessed on it as well, but the stuff's useful to know in terms of practice. Here we're starting to delve into sort of the duty aspect, and it's to do with delegation. So that trustees, it's a fiduciary duty. You've got a duty to act personally. That Spate and Gaunt case where they went and mapped that out. You can't outsource fiduciary duties, because if you think about it, it's like all of the other fiduciaries that we've encountered in law up to this point: company directors, partners, trying to think hospital products type situations as joint ventures. But you are ought to be aware from studying equity in the broad sense, these fiduciary duties are placed on you and you alone. It's not about abrogating that either through contract or somehow assigning your duties to someone else. You can't do that. Now, Queensland, and Queensland only, all of the jurisdictions have a statutory mechanism if you get sick. Natural people get sick, or they've left the jurisdiction for whatever reason. It's a year. If you're absent for a year, there is a statutory framework allowing the beneficiaries to come together, or the other trustees, or that particular trustee to nominate another person to act on their behalf in those situations. Now, that's modified, or can be modified by the instrument, curtailed in some way, in all other jurisdictions except Queensland. So here, you can't put something in the Queensland, in a trust deed in Queensland that says, no, you can't get someone else to fill in if they're sick. It's got to follow these steps. Queensland, when the Act is always going to apply. I do not know why that is. It just is. So just make note that your fiduciary duties flow from the general law. They are personal. You can't abrogate them other than by the statute, the statutory mechanism. The statutory mechanism, as we're aware, the carefully enshrined will of Parliament and legislation will trump the rules of common law and equity. Courts will follow what Parliament has said. And here they said, look, we're going to have some exceptions to this. And there are some other exceptions when I'll talk about duties shortly to do with agents and agency, but we'll come back to those. I'll take a shortish break, and I'll switch the slides over, and we'll come back and talk about duties then. So, if anybody has any questions, anybody got any questions on this? It's a bit rough at this stage on a Friday afternoon. It's pretty dry things. And look, I mean, this is an example of this area of law where we're largely just going through the statute. It's going through the Trust Act and looking at the sections and just having a bit of commentary in regards to those. It's not earth-shattering, and there's not relatively a lot of case law that flows from that as well. They're mechanical things, though, that sadly you kind of do have to take on board to some extent. The Trust Act's also quite readable as these sort of instruments go. It's a bit wordy in places, but it's still pretty straightforward in terms of reading how the Queensland Parliament has gone through and enshrined often the rules of equity and common law into the statute and then changed them for administrative convenience in a variety of places. That's really what this part's about. Okay, I'll hit that one up and stop, and we'll take 5 minutes.